All right, in accordance with the Open Public Meetings Act, PL 1975, Chapter 231, adequate notice of this regular meeting of the Planning Board of the Township has been provided. If everyone could please stand for the Pledge of Allegiance.
Okay. Can you hear me okay?
Yep.
Okay. Just remember when we're out here that if 2 or more people have their microphone on, it shuts down the whole system. So when you're done talking, make sure you turn your microphone off, including the professionals at the table. Okay. So Shaw Keller, Jennifer Ragnow, Charles Brown, and Mark Dancy were all here, but they were told to leave because they cannot vote. I just want them to get credit on tape that they were here and we told them to leave, so they're not charged with absence, okay? Bob LaCour is the same thing. Okay, Councilman Emerson?
Here.
Mahir Rafiq? Here. Robert Thomas?
Here.
And Chairman Orsini? Here. And Ted Chase? Sorry, I went right by you.
Okay, first order of business, regular meeting minutes. I guess it did what you said there, Christine. It should shut me down. Regular meeting minutes from June 18th. May I have a motion?
So moved.
I'll second. Already did, but that's all right.
Okay, so it's Councilman Embarson?
He made the motion, I second.
Yeah, I'm calling them to say yes or no.
Yes.
Councilman Embarson? Theodore Chase?
Yes.
Mahir Rafiq?
Yes.
Robert Thomas?
Yes.
And Chairman Orsini?
Yes. The second order of business is a resolution, HSU Property Holdings LLC. I will move that resolution.
Second.
Mahir Rafiq. Councilman Embarson?
Yes.
Theodore Chase?
Yes.
Mahir Rafiq?
Yes.
Robert Thomas?
Yes.
Chairman Orsini?
Yes. So the last order of business tonight is a discussion of the B9 consideration of conditions of approval. And for the rules of engagement, I will turn it over to Mr. Bernstein, our attorney tonight, and for instructions on how he charges the board and the public.
Mr. Chairman, just a quick clarification before Mr. Bernstein speaks. Just to clarify the reason why the 4 members were excused, 2 of the members were not on the board at the time of the original resolution, and the other 2 did not vote. So the 5 members that are here are members that were on board at that time and voted on that resolution. Just to make that clear for the record.
Thanks, Mark. I was clear. Great.
Mr. Chairman, thank you. Hopefully everyone can hear. It's on. Okay. We are here this evening courtesy of a decision of the Honorable William G. Menon, Superior Court of New Jersey Law Division. This board adopted a resolution denying the application for B9 Schoolhouse on September 26, 2023. His Honor, on May the 8th of this year, rejected that denial, determined that the board had in fact not had the basis to deny the application, approved it, remanded the application back for conditions, and we are here this evening to discuss the conditions. The matter is currently on appeal by this board as well as the intervener before the appellate division. We are waiting a decision from the appellate division as to whether they will accept the appeal or will wait what will happen out of this proceeding. The board is accepting the remand not because it wants to, but because it is under court order to do so. This decision tonight, any action taken by the board tonight should not be seen as an approval of or any action further taken relative to this application other than what has been previously decided and what His Honor has decided to remand back for the purposes of imposing conditions. That is the only matter before this board. I would advise members of the board to sit quietly and listen. I'll discuss the other ground rules in a moment, and to take whatever action you need to take once the public portion of this meeting is over. You will receive a brief, and I understand lawyers saying the word brief is like an oxymoron, but there will be a brief presentation from the applicant's counsel and the intervener's counsel. They have both have indicated they are going to make brief comments on the conditions. The board is under no obligation, because this is a remand from the court, to allow for a public participation portion of this meeting. However, as a courtesy to the members of the public, the board is permitting it under the following rules, ladies and gentlemen, and I have been asked, right, wrong, or indifferent, to call balls and strikes. And if you are minimally outside the strike zone, you are going to be asked to sit down. We are here only to hear comments, if any, on the conditions, not on the application, not on the decision of the board, not on the decision of the court, not on any other decision other than this limited issue related to the specific conditions. The minute you stop talking about the conditions or wandering off, I'm going to ask you to sit down on behalf of the board. And if it becomes too much, I'm going to ask the board chair to ask the board to shut the public portion down. I remind everyone again who has been here at these meetings that anyone who is represented by intervener cannot come up anyway, because you are represented by Mr. Wan and his firm, and therefore cannot speak, which was the same situation that occurred during the regular portion of the application. I remind the public, try to keep it brief, absolutely keep it limited to what the conditions are, which I believe many, if all of you should have. If not, there are some copies in the back. I would ask the board to sit quietly and listen. I would ask Mr. Lanford and Mr. Wan to come forward. They can battle, best 2 out of 3. Mr. Lanford, I understand, has a slight disadvantage. Mostly height and length. But he's bionic. Once they get themselves settled, I would ask Mr. Lanford, on behalf of the applicant, to go first, then Mr. Wan, and then the public under the limited application, folks.
I apologize.
Mr. Lanford, once you're ready. One thing before Mr. Lanford, there's only one important person in this entire room. This happy little young lady in the front who's taking stenographic notes for the purposes of the record and ultimately for Judge Menon and the appellate division and whoever else is going to hear this. So please speak into the microphone up at the podium, not from the audience. State your full name, spell your last name and where you're from. Be clear and concise.
Get right up and personal to that mic.
Can you hear me now? Thank you. Good evening, Mr. Chairman, members of the board. Peter Lanford, appearing on behalf of the applicant. First of all,
You got to put the mic right up to your mouth.
I really would like to take exception to the fact that this board is deciding to open this matter up to the public. As Mr. Bernstein indicated, after the 8 hearings in 2003, wherein the board denied this application, we took an appeal to the Superior Court. When we appeared before the Superior Court, we indicated to the judge that while we thought the board was wrong in denying the application, we also thought it was appropriate that if the court was to reverse the board's decision, that certain conditions should be imposed by the board. And we put that on the record, and there were 15 conditions. Judge Menon, in his opinion, said that when he remanded the matter to the board, and on page 41 said, for the imposition of reasonable conditions associated with the approvals granted herein, said limited remand shall be based upon the record already created below. This will permit the board to interact with plaintiff to suggest changes in conditions. It clearly indicates that the board is to interact with the plaintiff to come to certain conditions, not the public. Further, historically, and I've handled land use applications for 50 years, I have never seen a situation where the public gets involved with the imposition of conditions. In this town or other towns, the board will make a decision, and in deliberations, the board, in conjunction with discussions with the council, will impose reasonable conditions. The public portion of this meeting was closed in 2023, and I don't believe it can be opened for public discussion. The board's going to do what they want to do, but I'm going to object to any public input. Now, concerning the conditions themselves, as I indicated to you, when we appeared before the court, we suggested 15 conditions. When the court remanded the matter back, we provided those 15 conditions to the township staff. The township staff has issued a proposed 30-condition, 6-page memorandum to the board. Excuse me. I've had an opportunity to review those conditions and, quite frankly, take exception to 2, only 2. The first one is Condition 11. Condition 11 indicates that we shall be in full compliance of Chapter 169 of the Franklin Township Code, including but not limited to Section 19 F and G of said chapter and all other applicable Franklin Township Code requirements. The explanation says significant time was spent during the hearings discussing nuisances, Chapter 169, scenic corridor rules, complying with applicable code requirements. First of all, Chapter 169 was not adopted until 2024. So it could not have been the subject of any discussion in 2023. That's number one. Number two, because of the time of application rule, Chapter 169 should not apply. Thirdly, it's redundant. If this project is approved, and if this project is constructed, it must comply with all of the ordinances of the township as it applies to their operation. Not just Chapter 169, all of the ordinances. There is no reason for this language to be in as a condition of approval. It's redundant. This board has no enforcement provisions. Their enforcement provisions are with the code enforcement or code official if there are violations of this section or any other section of the ordinance. So therefore, it should not be included as a condition. Secondly, paragraph 22 indicates the building shall not be designated to be an H use as per the Uniform Construction Code. The explanation is, at the hearing, applicant indicated that they did not anticipate tenants would be H use. This is incorporated as a condition of approval. If you read all of the other conditions of approval and the comments, it says the applicant agreed to the above, the applicant agreed to the above, the applicant agreed to the above. We never agreed to this being a condition of approval. The only thing that took place regarding an H use was in the January 4th, 2023 hearing, when a member of the public asked Ms. Gaber, representative of the applicant, whether they intended to have any hazardous substances on the property. And her answer was, it wasn't our intent. She didn't indicate that she would agree to a condition not to allow it. And also, it's a construction code issue. If the building qualifies to have H uses, it should be entitled to H uses. This language has never appeared in any other resolution involving a warehouse in this municipality. The other thing that you have to consider is a prospective user may have a situation where they may need to have cleaning solvents or other materials on the property for the purpose of operating. Not that they're storing bombs or weapons or grenades, but they may be storing cleaning fluids and cleaning chemicals which need to be stored in a contained building or a contained structure in the building. That would qualify a portion of that building as an H use. This says we can't do it. I think, it is an inappropriate condition, not relevant. It was never agreed to by the applicant, nor was it discussed by the board at any time. Like I said, if you look at the transcript, January 4th, there was one sentence by Ms. Gaber saying we don't intend at this time to have an H use. She also at that time said we don't intend to have a cannabis distribution facility or cannabis growing facility. She made a lot of statements of what they don't intend, but that doesn't mean it should be a condition of approval. So other than those two conditions, I have no objections to the other 28 conditions. I also find interesting that this evening you have people that are here tonight, members of the board, that sat through the hearings and that voted on the resolution. And you're going to sit there and make a decision as to the conditions, which you should. But to allow members of the public who may not have attended any of those hearings, who may have never read the transcripts, who may have never read the court's decision, provide information or input for you guys to make a decision, I think is totally inappropriate. And again, I don't think this matter should be open to the public. Thank you.
I'm not going to comment on any of that, other than to say that I think that the board and the staff professionals stand behind the conditions we have tonight. I'm not going to litigate them or comment with you, but I will assure you that the public input is for courtesy and will not be considered by the board because these conditions have already been worked out with staff professionals, and these are our recommendations. We will listen to them as a courtesy. They will not change anything that you see before you tonight.
So what you're saying, Mr. Orsini, the two conditions that I object to, you're not going to change?
I'm not in position to change it because those were recommended by the staff professionals, and I think we would stand behind them. I'm not going to comment on their validity. I'm not going to comment on why they're in there. We've discussed it. The staff professionals have recommended these, and I don't think the board has the necessary expertise to discern cleaning solvents versus whatever. So that's for more highly paid professionals than me, anyways, to figure out.
Understood.
And by the way, I get paid zero, so that's a little.
Mr. Blanford, that's the comment of the chair. The board ultimately will decide whether to approve or deny some or all of the conditions. It's ultimately their decision. But we're giving the public a courtesy, as the chairman has indicated, and the board at some point later this evening will make a motion to address it accordingly.
Mr. Bernstein, just one last question. You indicated you were going to call ball and strikes with respect to comments that members of the public... I'm sorry. You indicated you were going to call balls and strikes concerning comments that members of the public may make. Do I have a right to object?
I will take your comments during your statement here as a standing, though sitting, objection to any and all comments, and therefore will be noted for the record accordingly. I don't think you have to get up every time you don't like something.
Maybe there's no need for me to be here this evening then. Thank you.
Go on. Note the applicant and the intervener are getting along for a moment.
Good evening, Mr. Chairman and members of the board. Michael Gann, G-A-N, from Lieberman, Blecker, and Sinkovich, on behalf of the Intervenor Citizens Warehouse Action Group. And really briefly, just as an initial matter, because Citizens Warehouse Action Group, or CWAG, as I may refer to them, was an intervener in this case, I do believe that we should have the right to participate in this and provide comments on this matter. We just have I have three proposed conditions to discuss with the board here. First off is that since at least July 25th, 2022, the applicant has been aware of, consented to, and was a signatory to another proposed 621,000 square foot warehouse on the adjoining property, which requires the use of this property for access to Schoolhouse Road. The other project also uses the new subdivided property from this application because this was also partly a subdivision application as part of that development. That application is pending before the zoning board. None of those impacts were ever discussed or revealed during this application, and we believe that these two projects were interrelated and this should have been presented as one project. Now I know that that's a separate project, it's being heard by the zoning board. All I want to suggest to the planning board here is that a condition of approval be imposed that if the applicant seeks to use the subject property as part of any other application, including for access or egress for any other properties, that this will be deemed a major modification and require a new site plan application to be submitted with the proper public notices. Number two is that during the July 19th, 2023 hearing, we had presented Mary Pace Goldman as our professional engineer, which was accepted as an expert witness. She had testified that the applicant's professionals had conducted soil borings in July 2021 and August 2021 to determine the groundwater table, which they ultimately used in their stormwater calculations. However, the New Jersey Stormwater Best Management Practices Manual requires that the soil borings to determine the groundwater table must be taken during the months of January through April. So those soil borings that the applicant's professional had conducted and relied upon for their stormwater calculations were done outside the permitted period of time. And because the applicant had argued that the soils do not match the mapped NRCS web soil survey, Ms. Pace Goldman had responded that the applicant could not use the alternative method and had to test the soils between January and April. Therefore, we are requesting as a condition of approval that the applicant shall reperform the soil testing in the correct time frame and confirm that the stormwater management system is compliant and properly designed in accordance with the stormwater management rules. And this was all testimony that was part of the record during the July 19th, 2023 hearing, and Ms. Pace Goldman had submitted an expert report for the board's consideration on that issue. Lastly, I believe paragraph 15 of the proposed conditions discuss the receipt of all necessary approvals from outside agencies as a condition of approval. We respectfully request that the condition expressly state that no site clearing, development, or construction work commence until all approvals are received and any conditions and approvals as applicable are met. Thank you.
Mr. Chairman, let me deal with them backwards. The issue of clearances and the like, the applicant is standard as its own risk. There is an ongoing litigation matter. Whatever actions the applicant takes that may ultimately be detrimental and/or contrary to a further court action will have to be dealt with at the appropriate time. And the township, I'm assuming, in my conversations with the applicable officials, have in fact addressed these and are prepared to address them at the appropriate time and in the appropriate place. Therefore, I don't think there is a need for an additional condition to be added. The issue of whether or not the soils were tested at the appropriate time, my recollection is that's part of the appeal on the litigation brought by the intervener, and therefore it is more appropriate to be addressed either before His Honor or before the appellate division at the appropriate time. The parties are aware of what the testimony was and try to take it into account in some of the conditions that are already set forth herein. As for the interaction between an ongoing application between the zoning board, which my office actually represents the zoning board as counsel, and this application, they are separate applications. They were not before this, that application was not before this board as part of this application. It was never brought before this board as part of this application, and therefore the appropriate place to deal with such, I would argue, is before the zoning board during the current pendency of that application. And if the parties, if the intervener or anyone else wishes to address the zoning board, I'm sure Mr. Thomas is thrilled by this comment, then that's the appropriate place and time, but not before this board. Therefore, Mr. Chairman, members of the board, I am not recommending the additional 3 conditions to be added.
Thank you, Mr. Bernstein.
I'm sorry, may I just really briefly clarify one point?
Your comments, Mr. Gann, are on the record, and they'll be dealt with accordingly at the appropriate times.
Thank you.
I'm trying to cut down the interaction between you and Mr. Lanford,
Understood.
as well as
Thank
the
you.
board. Mr. Chairman, at this time, if a member of the public not represented by either Mr. Lanford's office or Mr. Gann's office wishes to comment specifically on the conditions currently before the board for the board's consideration, please come to the microphone at the podium, state your full name, spell your last name for the record, indicate your address, and keep your comments brief and to the conditions. And as I indicated previously, the minute we veer, I'm going to ask that you step away from the podium. Thank you.
Good evening. My name is Anthony Riccio. I'm a resident of Canal Walk. I have no relationship with CWAG or Canal Walk Action Group. I'm going to limit, I'm sorry? R-I-C-C-I-O. I have a master's degree in economics from New York University and a 50-year matching gentleman over here, 50 years experience in both government and industrial development. I'm a retired industrial developer with partners in a company that had 8 million square feet and actually had over...
We don't need your qualifications.
Mr.
You're not a
Ricky.
witness. All you need to do is if you have a question
Okay,
on any of the
I'll read
conditions.
my comment, my amendment to 26B, and I'll leave this with you. Prior to a TCO or a CO, actual truck traffic counts will be made to and from the warehouses over a 24-hour period and traffic routes defined to calculate truck traffic and emissions. The Franklin Township Planning Board is to develop such a plan. Can I give my explanation?
Briefly.
The B9 submitted truck counts are not actual since the warehouse has no tenants. Off-the-shelf comparisons are not relevant. This number is critical since the current township traffic study points to a conclusion that current traffic volumes are dangerous, quoting, and when additional warehouses will accelerate to catastrophic. I don't need to say anything more. We have an action where this is missing. It would not add any other, what I think, any problems to provide that information, and it will provide for a more intelligent project approval. Thank you.
Thank you, Mr. Riccio. No. You didn't want the public to speak, and now you want to comment? No.
Good evening. My name is Vikram Bhargava. You can Google it, Bhargava, Okay. I live at 89 Constitution Way in Canal Walk, and I'm not a part of the CWAG or intervener, or whatever the term is. I'm just a resident of Canal Walk. Let me begin with a heartfelt gratitude to the board.
Sir, comments on the comment.
Okay, all right.
The board
Okay.
appreciates your thoughts, but
All
that's
right,
not what we're
okay,
here for.
all right. So maybe I can say this. Tonight we ask you to take the courage to for one more step by considering 4 additional conditions that are crucial to safeguarding our neighborhood. First, we respectfully request that the B9 should not grant access to any other adjacent warehouses or property owner developer through B9. As it stands, B9 anticipates 102 truck trips and 379 car trips per day. These numbers are from the traffic report by Dynamic Traffic submitted in June 2023. If another warehouse is granted shared access, that number could easily double or triple.
Sir, there is no other application before this board other than B9. Any other application that is either before this board or the zoning board is not part of tonight's hearings.
Okay. Second, a physical barrier be installed between the properties to prohibit access, and no future petitions or applications be considered for its removal or for the provision of access through B9 from adjoining properties.
Same comment.
Okay.
Next.
The third is specific to condition number 26. We ask that the noise generated by the air conditioning units and other operational equipment not exceed 70 decibels at the property line. This level, as defined by the Environmental Protection Agency, is a threshold at which prolonged exposure can begin to affect health, particularly among vulnerable populations such as the elderly. Sorry? Slow down. Okay. Okay. Third, we ask that the noise generated by the air conditioning units and other operational equipment not exceed 70 decibels at the property line. This level, as defined by the Environmental Protection Agency, is a threshold at which prolonged exposure can begin to affect health, particularly among vulnerable populations such as the elderly. Examples of 70 dB sound levels are...
Sir, next, number 4.
Okay. Fourth, we need to make sure that the construction is completed within a reasonable amount of time, say 2 years, 3 years, and that it does not drag on for years, disrupting the beauty and peace of the surrounding area. With this in mind, we require a strict, enforceable timeline of the building project from start to finish, with specific plans on how the debris, construction materials, and dirt on the road will be contained to a minimum.
I'll solve the problem easily. It is not within the jurisdiction of this board to determine the length or breadth of the construction schedule, which has positives and negative impacts on the overall matter. Thank you, sir.
Okay.
Hi, good evening. My name is Ivy Roberts. I live in Canal Walk, specifically at 15 Benjamin Street, and a lot of what I was going to say has been said, so I'm not going to say it, but I appreciate the courtesy of speaking at all. So I stand here tonight concerned about many conditions, especially item 2 and item 15. Item 2 is about municipal, and 15 is about other agencies, Somerset Planning, DRCC, Franklin Township Water, New Jersey Department of Environmental Conservation, Protection. And as you said, denials from these agencies could slow down or stop the construction. My concern as a resident is that we don't have a zombie property next door to us, meaning that it is partially built. So my concern is that, and I'd like to thank you for the opportunity to speak. Thank you.
Thank you, ma'am. I would, however, point out that it is not within the jurisdiction of this board to tell the various local, state, and county agencies, no matter how badly we want to tell them how to do and what to do, how long it's going to take them to deal with the applications.
Mr. Chairman, just to clarify, because the issue of outside approvals has come up, the applicant will not be permitted to start construction until all the comments in this, these conditions, all the comments in the staff reports, and until we receive proof of all outside approvals. So it's not going to linger because of some outside approval from the DEP or the DRCC. They need to get those approvals first, just to make that clear.
Thank you.
Hello, my name is Vimal Sudhani. I live on 14 Patriots Way. I'm calling about... Say it again. Vimal, V like Victor, I am Mary A.L. Last name is Sudhani, S-O-D-H-A-N-I. 14 Patriots Way. Now I'm regarding the condition number 4. As B9 will be cutting many trees, mature trees, the new trees will take about 7 to 10 years to grow. That to achieve that height, so planning board should request a modest $10 million bond for all the trees to be replaced, and return into about 95% of the trees grow minimum 40 feet high within 7 years. Else the bond will be forfeited. This is our request to the planning board.
Thank you, sir.
I can't speak to the $10 million figure, but a bond on perimeter landscaping is part of the normal process.
Good evening. My name is Frank Potetto. The last name is spelled. My last name is spelled B as in Bob, I-T-E-T-T-O. I'm assuming that the...
Where's your address, sir?
I'm sorry, 110 Canal Walk Boulevard.
Thank you.
I'm assuming that Somerset County has a noise ordinance, and I wonder if there's some consideration for mitigating the noise that will happen when trucks are backing up and you hear those loud beeping sounds and so forth.
One of the conditions deals with the compliance with the various ordinances for noise. One of the conditions is to require compliance with the noise ordinances. The county, the township, the state.
I'm sorry, can you repeat yourself?
One of the conditions being considered by the board this evening is a requirement that the applicant comply with applicable state, county, and local noise ordinances.
Thanks.
My name is Dhanraj Maheshwari, D-H-A-N-R-A-J, M-A-H-E-S-H-W-A-R-I. I am a resident of 28 Bryant Court, Somerset, at the corner of Schoolhouse and Midler's Road. I have not seen anything in this regarding traffic count on Somerset, on Canal Walk, in that area. That is why I would request for the following. I read the traffic impact study prepared by Dynamic Traffic and submitted to Planning Board on February 2023. The report shows number of AM peak street hour truck traffic of 38 inward and 11 outward, totaling 49. And PM peak street hour truck traffic of 15 inward and 34 outward. So
Sir,
within 52.
do you have a comment on the conditions?
Yes, my comment on this is really that, okay, these estimates, these are only estimates. Eventually, discount could be higher, much higher. What is the position of planning board on that?
Planning board can take no position on that. What happens in the future is left to that of the township and the applicable agencies to deal with it.
Okay, so this is what I want to suggest. To ensure compliance with the truck traffic limits specified, it is recommended that B9 should install a surveillance camera positioned across from the warehouse entrance. The camera should continuously monitor and record the number of trucks entering and exiting the facility. And all the data collected should be reported to the Franklin Township Traffic Department so that public has access to it and we would know whether they are complying with what they wanted to do. Another thing is really in case they do not comply with this, then there should be some clause to penalize them, whether it's a substantial fine or operational restrictions or revocation of permit as deemed appropriate by the township. Thank you.
Board cannot impose fines on an applicant or any other property owner relative to an application in terms of the surveillance camera and the imposition of traffic counts. I leave that ultimately to the township to address if and when this becomes an issue, if and when this application.
Well, okay. Anyway, thank you.
Board does not have the jurisdiction, if it wasn't heard, I apologize, does not have the jurisdiction to impose fines or penalties on any applicant, whether you like the applicant or not, as to the traffic counts and the surveillance camera to make sure that they're meeting the proposed study. I leave that ultimately to the township to address at the appropriate time and in the appropriate place when and if this application is ever A, approved and B, built.
My name is Dr. Stephen Brandt. I'm a professor of medicine at Robert Wood Johnson Medical School. I live at 22 Bryant Court, Somerset, New Jersey. I am B-R-A-N-T. I'm not represented by CWAG. I have concerns with the applicants not wanting to follow conditions 6 and 26, and also not having restrictions on what goes into the warehouse. So it must be understood that we are a vulnerable community. We're not like any other general community. We're populated by elderly people that are at risk for health conditions disproportionately. With regard to requiring a noise study, I believe that this is critical. It's been well demonstrated that increased noise, that for every 5% increase in decibels above a safe limit, there can be a 34% increase in risk of heart attack, stroke.
Dr. Brandt, Dr. Orsini here. 6 and 26 were never testified by the applicant as ones they would not comply with.
I'm sorry, I thought that they did not want to comply with the noise
With two,
ordinance.
those are not the two.
Oh, I'm
Peter,
sorry.
can you tell us the two again for reference, please?
Number 11 and number 22.
Thank you. Number 11 and number 22.
Number 11. So this the nuisances does refer to noise, though?
The only two conditions that the applicant objects to, and the board will ultimately decide whether to accept or not, are number 11 and 22. Otherwise, they are not contesting the other 28 conditions.
Okay. So I guess my understanding of condition 11 is a nuisance, and that is a noise nuisance.
Thank you. That's their contention, that the ordinance does not apply because it postdates the time of application.
Okay.
The board will address it accordingly.
So I believe that ordinance has to do with noise, and I'm talking about the importance and critical nature of noise to our particular community, where we know that cardiovascular disease, heart attack, and stroke are two of the major leading causes of death, and they increase with age, and hence our community is disproportionately affected. We have the right as neighbors, and that's why we were notified to come to this meeting to be protected from by Franklin Township and the state of New Jersey and the planning board against environmental concerns from the building. So therefore, I do hope that you will take the importance of having the noise ordinance to protect us.
That's why it's in the recommendations, Doctor.
Condition 26 addresses noise.
Hello. Hello, my name is Jeffrey Green. I live at 30 Patriots Way. It's green like the color. My comments pertain to item number 22, which state, at the hearing, the applicant indicated that they did not anticipate tenants would be hazardous. The word anticipate is a nice word, but the trouble is in 6 months or a year from now, there may be such a situation where that could occur. I would like to make a proposal or recommendation that one of the conditions here state that the applicant put in their contracts with their customers or clients that they do not contain hazardous materials.
It's not within the board's jurisdiction to advise the applicant who it should or should not contract with. The condition indicates it will not be designed to be an H-use and that no H-use will be permitted on the site. That's well within the purviews of what you're suggesting. It doesn't have to be in the contract. If they're in violation ultimately, it'll be up to the township and or other applicable governmental entities to enforce.
All right, so it's a township that has the oversight on this. Is that what you're claiming, sir?
That's what I'm stating. Claiming is a wrong word to use with a lawyer.
Thank you.
Good evening. Michael Bryan, B-R-I-E-N, 40 Bryan Court. Mr. Bernstein, I just want to let you know I've shortened the things I was going to say based on your instructions, and I will try my best to adhere to it. At previous hearings, the applicant did not provide the planning board with an adequate environmental study. Why is this important that the planning board be provided this study?
Mr. Bryan, let me shorten it even further. The issue of the environmental impact statement and the environmental study were issues relative to the board's decision, which is currently on appeal before the appellate division, relative to same.
Okay.
The board cannot impose a condition relative to that. That has to be adjudicated accordingly.
Okay, I'll accept that. Okay, now, the applicant is proposing a warehouse within 100 feet of residential property.
They're not proposing. Let me again, and I apologize. I'm sometimes becoming my mother's son. Well, you may remember my mother. The application is done.
Okay.
We are, right, wrong, or indifferent, we are beyond the board
Okay,
hearing the
I understand.
application. We're here for the conditions only.
Okay, so let's talk about conditions. I believe that no truck should enter the warehouse unless their emission systems are modern, up to date, according to the federal government, New Jersey standards in the Township of Franklin. Okay, is that okay?
That's your comment on a condition, but it's not a condition this board can impose.
Okay. Okay. Could I say one other thing? This is not only about Canal Walk. It's about Summerfields also, which is a very densely populated community.
We understand the geography. Do you have conditions on the comments, the numbers of the comment? Just the number of the comment and any comment that you have, please.
Okay. I don't believe there should be any idling in the warehouse. Okay. I believe.
Not a condition that we can address.
Well, there's a state anti-idling statute. That's something that they'll have to comply with. Don't worry about it.
I believe there should be a 5-mile-an-hour speed limit on the warehouse property. Okay?
Thank you, sir.
I think if I say anything else, it's not going to work. Thank you for the time.
Hi, I'm Wendy Park, PA-UK, at 134 Canal Walk Boulevard. What I'm going to request, you're going to say you can't do, but I do think I would like to see air quality monitors along, since we're talking about this specific warehouse, which is against opposite residences, I'd like to see air quality monitors put along the residential area across from the warehouse with possibly noise monitors, because even the weather station lets us know if we should not go outside, or we should have to close our windows or live indoors indefinitely. I think that would be a way of monitoring that would be effective for us.
It's not a condition within the purview of the board.
Brad Ferenz, 93 Saratoga. Thank you for hearing.
Can you spell your last name, please?
Brad Ferenz, 93 Saratoga.
Spell your last name,
F as
sir.
in Frank, E-R-E-N-C-Z.
Thank you.
Two things. There is an objection to 11 and 22. On 11, the applicant indicates that it's redundant. Well, if it's redundant, why are they objecting? And I urge the board to keep paragraph 11. On 22, they said, according to what the applicant said, we don't intend to use hazardous waste. We don't intend to at any particular point in time is something that can be changed tomorrow or the next day. I urge the board to keep paragraph 22.
Thank you.
Short and sweet, Shauna College, COLLIDGE, 2201 Jockey Hollow Trail, Somerset. Have one quick comment or a request for condition number 11. How about emergency preparedness? Do you have a plan for emergencies, including fire, chemical spills, and security incidents? So that's a thought. Do you have a plan? That's my comment.
Ma'am, unfortunately or fortunately, that is not a condition within the purview of the board. It is ultimately a condition of the township in reviewing building plans and approving such.
Thank you so much.
My name is Roberta Henry, Henry. I reside at 3209 Enclave Circle in Canal Walk. I'd just like to answer to Mr. Bernstein saying I have been at several of these meetings, and also spoke at the meeting where the vote was taken. I'm also a nurse. I've been a nurse for 63 years, and I've cared for people with a lot of pulmonary issues, and also in reading and investigating that bladder cancer is also a condition of exposure to diesel emissions. Although you mentioned that there will be no hazardous materials in the warehouse, I would like to know how diesel fuel emissions that we will all be breathing is classified. Is it not classified as hazardous? So how do we classify those reports? I mean, we are under now from wildfires that are so many miles away. We're under pulmonary watch.
The board has no jurisdiction over the wildfires.
I'm just saying,
Canada.
but I'm just saying.
I understand your point.
Okay.
The issue about H use in accordance to condition 22 is as it is defined under the Uniform Construction Code.
I'm just saying that these diesel fumes are going to be there in our community with elderly people and grandchildren visiting.
We understand.
Okay. And I'd like to comment, refer to condition 2, which refers to full compliance with township and county reports, including Somerset County Health Department records. Have those reports been received and have they been reviewed? And is everything in compliance?
Nothing has, these are conditions for the application and the applicant to go forward. Once they get approval to do so, they are going to have to comply with those as well. They have, whatever has been reviewed at the end of the table by the appropriate personnel, and the ones that will come will be reviewed by the township accordingly.
Thank you.
Good evening. My name is Harish, Harish, D as in David, ALAL, live on 26 Patriots Way. We've talked about the arms and the legs and the nose and everything about this project. What we have not talked about is the heart. The heart of this project says the people of Canal Walk do not want the warehouse there. And
sorry, that's no.
I know I'm late, but
no,
this is...
balls and strikes, you just struck out. Please sit down.
I'm fine. I struck out.
My strike zone's tighter than Mr. Bernstein's, believe it or not. Seeing nobody else from the public coming up, can you charge the board with what we have to do?
One more person.
We got one more person? All right, line up, because I want to make sure that everybody gets heard, but I don't know if you're not there.
My name is Nancy Byrne, B-E-I-R-N-E, and my husband and I reside at 26 Ryan Court in Canal Walk, 150 feet from the B9 warehouse.
Ma'am, conditions.
What?
Speak to the conditions, not where you live in terms of your distance.
I'm extremely concerned about the carcinogens emitted by diesel truck traffic.
And the board has already commented accordingly.
Okay, therefore I cannot propose an air dispersion model? Okay, thank you.
Chairman, at this point, we're looking for a motion to close the public hearing.
So I move to close the public hearing.
Second.
All in favor? Aye. Just so you have that, Christine, I made the motion, Maher second. Mr. Bernstein, can you give the board some instructions on our next step here?
What we are seeking, Mr. Chairman, from the board is the approval of the July 29th, 2025 Technical Review Committee recommendations to the Planning Board, which contain 30 conditions to be added to the application pursuant to Judge Menon's decision in the sense of the requirement to have conditions, and to refer these conditions back to the court for the court to determine whatever action it will take depending upon the actions of the applicant, the intervener related thereto. So it is a motion we are recommending. Myself, Mr. Mazzei, Mr. Healy are recommending the adoption of this recommendation in full as proposed.
I will make that motion to approve the 30 conditions recommended by the staff. Just a second, Bob, or not? Don't, please, no discussion. I don't want to add anything to the record here. Please. Do we have a second?
Did Bob second? Okay, Rob second. Councilman Larson?
Yes.
Theodore Chase?
Yes.
Mahir Rafiq? Robert Thomas?
No, I'm opposed because I was told that we were able to add conditions, potentially add conditions.
Okay, I marked it as a no, Bob, I can hear you. Chairman Orsini?
Yes.
Okay.
Motion carries.
Christine, do we have anything else for tonight?
No, we do not.
When do we meet again?
When do we meet again?
September 2nd?
No, September 3rd.
September 3rd. Okay, make a motion to adjourn. Everybody enjoy the rest of your summer.
Second.
All in favor? All right. Meeting is adjourned.